Welcome.
Hello and welcome to the Cybersecurity Leadership Series organized by Cyber Houston. We are live and excited to have you join us today. In this series, we highlight our cybersecurity rock stars or masterminds and bring you valuable information, especially during this COVID-19 pandemic. I am Umesh, Verma, CEO of Blue Lance and the founder of Cyber Houston. We thank our sponsors, Hewlett Packard Enterprise, Blue Lance, Reneka Digital, and the University of Houston Downtown for underwriting the Cybersecurity Leadership Series. We love getting questions from our viewers. So if you have a question or comment that pops up anytime during the session, please enter it in the live chat section on Facebook or YouTube beside the live video, and we will try to answer as many as we can. Also, we are just like everyone else. We love being loved. So show us some love by hitting the like button and cheering us on. And remember to subscribe and hit the notification button. That way YouTube and Facebook will automatically notify you whenever we are scheduled to go live. So today's topic is the challenge ahead, the California Consumer Privacy Act's reasonable security rule. In this broadcast, we will discuss security measures that have been pre-approved and endorsed by the California Attorney General's office, and for practical takeaways about how to budget for, implement, and maintain these security measures into legal risk compliance programs. So it is our pleasure today to introduce our guest, Elizabeth Rogers, a former chief privacy officer in Texas state government. Elizabeth brings a unique and informed perspective to her privacy and cybersecurity practice at Michael Best. Clients benefit from Elizabeth's extensive experience with a variety of regulatory cybersecurity compliance and technology-specific privacy matters. Outside of her law practice, Elizabeth teaches cybersecurity and privacy law topics for the University of Texas School of Information's Master's Program in Identity Management and Security. She is a thought leader on privacy and cybersecurity matters facing businesses, and frequently speaks and is published on emerging trends in these areas. Elizabeth is an advisory board member of UC Berkeley's Global Cybersecurity Institute, a council member of the State Bar of Texas's Computer and Technology Law Section, and a member of the Greater Houston Cybersecurity Council. She is an active supporter of the arts and currently serves on the boards of directors for the Mexic Art Museum, Kids in a New Groove, and Texas Accountants and Lawyers for the Arts. So welcome, Elizabeth. It's so good to have you here today.
Thank you, Umesh. It's an honor, and I'm humbled to be introduced by a rock star like yourself.
We are rock stars anyway. So Elizabeth, I was thinking about this, and we got together. We met about maybe 6 years ago. I don't know if you remember this, but that at a World Affairs Council meeting, you and I were on a panel and in Austin, and we were talking about privacy and security then. And at that time, GDPR had just come out, and we were talking, and that's how you and I kind of got together. And then you have been such a supporter of Cyber Houston, and for our viewers, Elizabeth has been one of the key contributors to the guidance for the board of directors, cybersecurity for the board of directors, and that guidance is available on the cyberhouston.org website. But you've been so involved, and you shared a few fun facts with me, and I'd like to share some things with the audience. But so you grew up, when you were growing up, you had a hot rod while you were in college. What was that story about?
It was pretty scary, to be honest. I grew up in a very small town. There were no freeways. My mom took me to school until the very last day of my senior year, but I took the one car she let me have was a Cadillac DeVille that got about 12 miles to the gallon. And before long, we knew that that was not going to be a college student's best investment. So I had an uncle who is a criminal defense attorney, and he had a 1969 Dodge Charger with a 350 Holly engine that he had received as a retainer from one of his clients. And I ended up being the owner of that car. And at red lights, as an 18-year-old, people next to me would run their motors and act like they wanted to race me down Mesa Drive. And I delicately said, no, yeah, I'm not going to race you. But it was a lot of fun. It was a lot of fun to have that car. It was actually burnt orange with a white, with a white roof. It was really pretty. I was lucky.
So that was right about the time that Grease was coming out, right? So people were probably thinking about you lining up on Mesa Drive and just kind of revving and racing down car for car, right?
Right. Yes. No, I definitely wore no leather jackets. I didn't want to give anybody any wrong ideas.
And the powder puff skirts. Yeah. Okay. So then you grew up right across from where Nolan Ryan, our Astros superstar pitcher, was.
Yes, that was such a pleasure to get to know what a humble man he was. I'm the oldest, and my two little brothers would run across the street every time he went to count the head of cattle on his lease. He owned a cattle lease across the street, and he never hesitated to take a picture with them. And back then it was those little Instamatic cameras that you could take to CVS and get your photos developed. And so they took several to make sure at least one of them would be good. And so he was such a great contributor to our community as well, donating land for baseball parks and really supporting youth baseball. So it was a great place to be from.
Yeah, he's been a great Texan. And so that brings me to your legal career, and you helped pass a bill that was litigated in the Texas Supreme Court that protects the privacy and addresses of all attorneys. You want to kind of talk about that? Because I think that's a great precursor to what we're going to be talking about today.
Yes, I found myself in the position as General Counsel of the State Bar of Texas. There had been a tragedy involving the shooting of a defense attorney, a criminal defense attorney, and in their driveway. So one of the defendants who had been represented by this attorney found out where the attorney lived and shot the person while they were at their home. Prior to this bill and the Supreme Court case, the only addresses that had been protected under the Public Information Act were those of judges. And so we first filed a lawsuit under the Public Information Act that attempted to interpret the Public Information Act as protecting this information as confidential by law. And it went all the way up through the Supreme Court, and it won the day before the bill that we worked on with the president of the State Bar actually became effective. So it was belt and suspenders. And so that was before I entered my privacy career, but it was very rewarding and hopefully has mitigated the risk of anything like that happening again.
And so, we have so much, you have such a long career in privacy and security. And, so that was a great start. And that kind of brings us, we kind of have seen you go through the GDPR side, and now you're working on the California Consumer Privacy Act, CCPA for short. And, that legislation has just found its legs very recently. It's been litigated and been modified over several years. But a lot of people say it's the first of its kind here in the United States that kind of models to some degree GDPR. Now, there are differences between GDPR and CCPA, which I'm sure you'll get into. One is regulated and one is a guidance. But the legislation states that companies need to provide more information to consumers about what's being done with their data and give them more control over how or if that data is shared. And that's a very layman's definition, but I'm sure you'll be. So that takes us to your presentation. And so I turn it over to you because you have a very distinguished career and very well thought of and a real thought leader, and you're working with global companies as well as the state of Texas. And there are all these ransomware issues that are coming up right now, so I'm sure you're going to touch on those. And so we'll get questions from the audience. I encourage our viewers to pop in their questions, and we will answer, we'll interject them as we go along. So with that, over to you, Elizabeth.
Yes, thank you, Umesh. That's a great introduction to what we're going to be focusing on today. And just as to make a note for the record, if you're watching this recording after today, you will be happy to know that the actual enforcement date for the CCPA was only 2 weeks ago on July the 1st. We'll go through a little bit about the history of how the law got passed, a very high-level discussion of who is covered, what it covers, what consumer rights there are. But the focus I wanted to bring to the audience today is the actual reasonable security requirement, because that is something that we believe will be a requirement that is a part of every law that relates to privacy, either in a state-by-state basis, or in the common law, or in the actual federal government. I'm going to put on my earbuds just in case there is any problems with all of the hearing background feedback. And try that and see if that will help you. A better sound. I essentially just wanted to make sure that I know people might be thrown off here by focusing on just one state's Privacy Act. But the reason we're focusing today on the California Consumer Privacy Act is because California is considered to be a pioneer in privacy legislation. They were the very first state in 2003 to enact the A data breach notification statute. Since then, they have also passed other laws, including the Shine the Light law. But what really, I guess, was the impetus of this particular legislation is the Facebook Cambridge Analytica scandal, and the fact that it finally dawned on all the lawmakers that they are the home, they're the headquarters of some of the world's largest technology corporations that collect consumer data, such as Facebook, Google, Apple, and others. That Netflix. The only larger corporation that probably has more is Amazon, and it's headquartered in Washington, and also Microsoft. And that is another state that's actively trying to get one of these privacy acts passed. So, like I said, we're going to discuss a lot of the components of the law from a very high level, but we believe that this reasonable security standard is going to find its way into every single act like it, whether it's on a state level or national level. And I think it will help all of us in the audience to be educated about what the educators and the courts are saying is reasonable security. So, I need to make the slide screen move. It's not moving, Leslie, for some reason. Okay. All right. So just starting from the beginning, the California Consumer Privacy Act was passed about 2 years ago, and became effective on January 1, 2020, right when the fireworks were going off for the new year. It's already been updated. The regulations that were issued in October
have had 3 different versions. They were finally released by the California Attorney General on June 1, and were turned over to the California Office of Attorney General and submitted to the California Office of Administrative Law. Normally that office has 30 days to review, but because of the quarantine, that review will be extended by 60 days. So we will be lucky that if we have the final draft approved by October of 2020, which is just about a year after the drafts were first issued. So from a high level, the CCA protects California residents. There's a lot of definition around who is a California resident, but for the most part, realize it's not just someone who's temporarily in California, it's someone who calls California home. Currently, there is an exemption for employees, and that is until January of 2021. We don't know yet whether that exemption will be extended or the law will be amended to exclude employees. They may amend it the other way, but even though they are exempt from the CCPA, there is a limited application to provide them notice of their rights to file a lawsuit following a data breach. So, as all of these new consumer rights and disclosures that need to be made really only apply if the business falls within the definition of a covered entity under the Act. And so, for that purpose, think of any traditional, conventional type of business operation. It could be partnership, corporation, sole proprietorship, that collects personal information from people that are California residents and has to satisfy just one of any one of these 3 thresholds. And one is they have an annual gross revenue in excess of 25 million. A second one is this is the alone or in combination buys, receives for any kind of commercial purposes, sells or shares the personal information of 50,000 or more consumers, households, or devices. So the last category of information that's collected, the information about devices, can quickly be achieved in a year if you consider that sometimes there may be more than 100 California residents visiting your website every day. If that's the case, then you can see how quickly it would add up that you would have information about 50,000 devices on your collected just by virtue of the fact people are visiting your website. And then the third category is that company may derive 50% or more of their annual revenue from selling consumers' personal information. And that we'll go into the definition of selling in a short minute because that is not as straightforward as it sounds. What I do like to focus on to make this, to help people realize what a game-changing law this is, and I know that the regulations try to clarify some of these categories of personal information, but for now, please know that they're way beyond the traditional definitions of personal identifiable information, and they extend to, in fact, the olfactory preferences or the scent of someone, in fact. But it also includes information you would find on a resume or an application when someone applies for a job. The one that is probably the farthest reaching, in my opinion, is the internet or electronic network activity, which would include the consumer's browsing history, their search history, the information regarding the consumer's interaction with the website, an app, or an advertisement. So the one thing that is also becoming a very hot issue under the CCPA is ad tech information in the ad tech industry, where there are inferences that can be created about a person based on the sites that they visit, the web pages they look at, um, any psychological trends, abilities, or aptitudes that's picked up from that information is now considered protected by law. And so what is the big change? So now, whereas before there had to be some disclosures under other California laws, there's now a requirement that there be a privacy notice. And it's not limited to online privacy notices. So that means that for operations in the state of California that actually serve California residents, there must be a disclosure of what categories of personal information will be collected during the transaction, what purpose that information will be used for, and and the purposes that it will be used for by any third parties that the business does business with. And so there's no clarification about what that looks like in the regulations. Is there a landing page? If it's a brick and mortar operation, is that in the store window by the cash register? Do these point of sale privacy notices need to be in the actual mobile application before the transaction is completed? There's various unclear parameters around that.
Elizabeth, we have a question coming in from Andres here in Houston, another member of the Greater Houston Cybersecurity Council. He says, what's the responsibility of companies providing services that have to comply with CCPA? For example, backup or IT services. And I think that relates very well to your last slide.
Yes, absolutely. So the responsibility is to, first of all, the business that does business with the service provider is now required to add language in the contract with that service provider that restricts the service provider from forwarding on that information or using it for any other purpose other than the business purpose that is stated in the MSA or other contract between the business and the vendor. And that does it does a major thing for that business. And that, pardon me, what it does is it puts that exchange or that disclosure of information to the service provider into a category that's exempt from being considered a sale. So as you see on this slide, there's a lot of words that are used to define what a sale would be. Disclosures, making it available, simply transferring it. It doesn't even have to be for money. But if this is a common occurrence between the business and a service provider, that the service provider gets the data, then there needs to be language in the contract that limits how the service provider can use that data, and any disclosures in case the data is used for purposes that weren't disclosed to the consumer, and that will make it not a sale. I hope that answers the question. Another exempt category of sharing a consumer's data is when the consumer tells the business to do that. So for example, if the consumer does business with, let's say Pottery Barn, for example, and Pottery Barn likes to share that data with West Elm and Williams-Sonoma, Pottery Barn Teen, all their affiliates, that has to be disclosed in their privacy notice. And if the consumer signs up for a reward program among all of those stores, it is basically, that can be interpreted as telling those stores to disclose the consumer's information among all of those affiliates. So that's an example of how the consumer can tell the business to use its own personal information. In the area of broad consumer rights, that's what everybody has been hearing about mainly. This is the part of the CCPA that sounds like the GDPR. And if your business, or if you serve a business that has already gone through the process of getting ready for the GDPR by May 25 of 2018, chances are highly likely that you're almost compliant with the CCPA. If you, for example, have gone through data mapping, you've gone through accountability of the business to protect the data in writing. The one thing that may need to be done, of course, is the do not sell feature, which distinguishes the CCPA from the GDPR. But otherwise, you'll see very similar rights for consumers in the right to disclosure, with the consumer having the right to request the business to disclose all the various categories of third parties that receive their data, or deletion. For example, if a consumer has decided they no longer want to hear, they've finished the transaction with the company, or they've decided to end a relationship with the business and they want all of their data to be removed from the systems, that is in the GDPR, the right to be forgotten. And then, of course, the right of portability, to be able to remove the data in a format that can be easily transferred to another, perhaps, business that is a competitor of the business that the consumer would like to remove the data from. All the forms that go along with those also have to be made available to the consumer. There is a requirement to, if you're not an e-commerce only business, there is a requirement to have a toll-free number available for consumers to phone these requests to the business. There's also a requirement to have an address, either an email address or a physical address that they can contact to submit these personal rights that exist now in the CCPA.
So, Elizabeth, you spoke about data mapping, and that's from the release of information perspective. And then there is this whole area of what's called ROT, redundant, obsolete, and trivial data. And so, do you have any information on what is the liability of companies keeping very old data around that may or may not be viable anymore, and yet it has a lot of sensitive information that could get breached or leaked or have to be released upon discovery?
Mm-hmm. So essentially, the CCPA does have the requirement that the data should not be retained by the business after the purpose for having that information has expired. So, for example, during the transaction and up through shipment of an order, for example, it is fine for the business to retain the transactional data of the consumer. And in fact, if you're an online shopper like me at Home Depot, I don't want to have to re-enter everything every time I order an air filter, right? But once that purpose has expired, there is an expectation that there needs to be a legitimate business reason to have that data. Otherwise, it should be retained or disposed of and deleted.
So are we going to expect to see stores and other online retailers begin to send us regular notices to kind of resubscribe and opt in, or to keep our data alive? Or do you see that as just being a one-time opt-in?
I believe that there will not be a trend of that occurring, because there are rights for the consumer to opt out, for example. And then in the regulations of the CCPA, there's a period of time within which the business has to wait. It's 12 months from the date that the person has asked to be deleted or forgotten. So if it does happen at all, it would happen only on an annual basis.
Got it. Thank you.
You're welcome. So here is really the heart of what I thought we could focus on today, because of the fact that not only does the do not sell function of the CCPA separate it from prior privacy laws that protect consumers, but also the private cause of action, of course, that everybody is talking about since the enforcement date began 2 weeks ago. And that private cause of action arises following a data breach if that data breach results from the business's failure to implement reasonable security practices and procedures. And so, whereas before, only attorney generals could, in all the other 49 states, the attorney general is the one that brings a large lawsuit against the business for a data breach. This is the first time that plaintiffs' attorneys are able to represent many class members. There are, and the other thing that makes this such a, departure from the past is that statutory damages can be collected, not just actual. And that is a huge change, because the most difficult aspect of filing a lawsuit after a data breach in the past has been people have had difficulty establishing harm. In this case, statutory damages start at $100 and go up to $750 per consumer per incident, or they have the availability to pursue actual damages if they believe that their damages would be greater. And just think of that, like if your breach has affected 12,000 people, even just paying $100 to each of those consumers can be extremely costly, on top of all the other expenses associated with a data breach. The one thing that that will be also, I think it's important to note, is that there is also steep penalties that the Attorney General can enforce on a business for other violations, starting at $2,500 for each violation. For example, not responding to a consumer request, not disclosing what information will be collected in your privacy notice. So those go up to $7,500 if let's say the business just ignores the Attorney General's original notice or doesn't care. And there's aggravating factors that will need to be established for the $7,500 fee to apply. In those particular violations that involve failure to respond to consumers or failure to act when they've requested information, you have a 30-day period to cure. But for breaches, data breaches, it is unclear how that right to cure might be available to a business. So we're going to have to wait and see how the Attorney General enforces that. But getting to the issue again, we've seen the reasonable security standard it was born out of negligence law, the reasonable duty of care. And so naturally, regulators, lawmakers, anyone that is enforcing a law or a part of the legal system involved with a data breach is using this standard. So now we have to look at what do the courts think that a reasonable security program is in 2020? What do the enforcement agencies think that is? And what will Congress think that is? So far, we know that the courts and the regulators look at whether or not the company did something when they knew something. That was the very biggest question in the Wyndham Hotel breach about 7 years ago that kind of set a lot of legal actions in motion. And so they had 3 data breaches in a very short period of time. And the lawsuits that were filed against Wyndham after that alleged negligence because they didn't exercise the right duty of care of all of the data. They failed to apply the right standards that would have protected their information. Even after the first breach, the report, the incident report, did not rise to the level of the executives. It was only provided to the information security stakeholders, who did not elevate it to the executives, and essentially, not to oversimplify, but essentially nothing was done following that, receiving that report. And that was revealed in the second and third data breach. So the question arises, why isn't there something more prescriptive that people can follow? And the answer is twofold. One, part of the challenge, as we all know, is that the threat landscape is changing every day. As I was visiting with Umesh, I'm dealing with a really robust ransomware attack right now. It involved not only the encryption of everything on about 5 servers, but also an exfiltration of about 700 gigabytes of information. It's a Russian malware called Neshta, and it binds itself to the applications and the servers and makes it extremely easy to forward things out to Russia. So we're dealing with not only the deadline for the ransom is today, but also waiting for the FBI to release the folders that were in the servers that have been exfiltrated, to see whether or not there's personally identifiable information. So keeping up with all the new malwares, the new things that those malwares do to systems is extremely important. And if there were prescriptive requirements for the standard, then they might be out of date tomorrow if they were passed in January. So that's the good news. The other news is that for those states that are business friendly versus being consumer friendly, they just wouldn't work because it would affect probably all businesses. There would probably maybe be a threshold by revenue like the CCPA, but otherwise nonprofits and for-profit companies would be under an extreme amount of burden to implement prescriptive requirements. So for now, we need to work within the wilderness here a little bit, and just as the days go by, learn more about what the courts define the standard to be, and all the regulators as well. So starting out with the courtroom and what judges might say if they're looking at a data breach or a compromise of some sort. One of the biggest challenges, I think, as a lawyer and for our clients, is a lot of the judges really don't know, a lot about information security or technology. And so we're hopeful that they have clerks working for them that can help advise them, or that they are educating themselves. But for now, they're using this standard definitions for reasonable care that they have applied in many other types of cases, like personal injury. So if a defendant is sued, the general rule is they attempt to establish that their actions, like what they decided to purchase for their information security program, conform to what everybody else in the same industry was doing, and that is their defense to avoid liability, that they followed exactly the same protocols that everyone else did. And in reviewing that evidence, when the courts, the judges, the juries are looking at what the plaintiff is alleging and what the defendant is saying to avoid liability, they use a risk utility test to see whether or not that conduct conformed to what others were doing that are similarly situated, or if the potential harm outweighs the burden of implementing any kind of controls to prevent such harm. So this goes back, in fact, to a tugboat case back in 1932 involving a group of tugboats owned by a company that all sank during a storm, resulting in the loss of cargo. There was no loss of life, thank heavens, but cargo was lost. And so the plaintiffs argued that all the defendant tugboat company was negligent for not putting radios, receiving sets on the tugboats that would have warned them of the storm and prevented the loss of the cargo. In turn, the tugboat owners argued they're not liable because at that time, radio receivers were too expensive to install and maintain, and that radio sets were inside of tugboats were not among the prevailing standard of practice in the industry. Well, at the end of the case, the judge ruled for the plaintiffs, saying that the burden of implementing this measure was far below the risk of harm that would have occurred, and so they were held liable. So many of us have heard the same reply from businesses, even in 2020, in the context of breach prevention. Many companies will say, we have, the cybersecurity measures beyond what we've got, they're too expensive, but we should be fine because we implement the same measures as others in the industry. Courts are getting less and less tolerant of that response, and they're requiring much more evidence of accountability to protect sensitive and proprietary information. So it's also important to remember that the courts and the FTC do not only look at like the technical steps that a company has taken, they look at the communications the company has made to consumers. And they either call it fraud or they call it negligence, because many times a company will tout that their information security program is adequate or beyond adequate. For example, in the Equifax breach, shareholders brought a shareholder derivative suit against Equifax alleging it committed fraud because they made multiple false or misleading statements and omissions regarding the vulnerability of its internal systems to prevent a cyber attack. And also they overstated their compliance with data protection laws and cybersecurity best practices. So it's not sometimes just the failure to implement a reasonable solution, but it's also what have you said to consumers of your business product. So that's the birth of the reasonable security standard in the common law. And moving on to the FTC's reasonable standard, it's very similar. The FTC has not passed a law, so it doesn't have a statute it enacts. However, it does have enforcement authority to prevent unfair and deceptive acts against consumers under Section 5 of the FTC Act. And so that's where it's found its authority in the Wyndham case. The Third Circuit Court of Appeals agreed with the plaintiffs, and the FTC has been enforcing whether or not a company has adequate cybersecurity ever since then. I highlight the Equifax settlement to demonstrate and illustrate what the FTC considers to be reasonable security, because it's probably the largest settlement aside from Facebook that the FTC has reached in the last 3 years. But it's very instructive on the errors that it believed Equifax made. And I'll preface this brief discussion just by saying I had a meeting actually with the commissioners of the FTC in their offices in the fall of 2018. All of them had just been appointed. They come from very different backgrounds. The one that I knew who welcomed me and my partners into the commission is one that used to work for John Cornyn when in his Senate office as privacy counsel. And I had a relationship with him. Every time I went to Washington, D.C., we would talk about privacy issues being discussed in Congress and then the Senate Judiciary Committee. But now he found himself as a commissioner in the FTC asking, what should the reasonable standard of care look like? And the reason he took that so seriously and why lawmakers should is because the consequences of finding a company does not comply with that standard are devastating in the form of penalties and fines. They can literally put a company out of business like it did LabMD. And that's an interesting case to read if you all want to know more about what was considered unreasonable. But in the Equifax settlement, since it's so recent, I didn't include the facts that caused the breach. This page is so crowded, slide 20 is so crowded, just with the number of inadequate security measures the FTC found. So again, using Section 5 of the FTC Act and finding violations of the safeguards rule under the Gramm-Leach-Bliley Act, they found several. First of all, under FTC, remember the rule is not to deceive or be unfair to consumers. The FTC declared the Equifax deceived consumers by saying it had a highly sophisticated data information network, when in fact, all of these failures occurred. Essentially, they had failed to patch the JavaScript in their environment, and they were issued an alert by US CERT, which oversees these massive vulnerabilities, to ask all the employees to patch the JavaScript, and they didn't follow through. And they had a scan, they were trying, but they had a scan that wasn't configured to scan all the assets in their environment. So there was a huge system that was left unscanned, and that therefore the intrusion occurred on that particular system that wasn't patched. And on top of that, even though it had all of these multiple hundreds of millions of social security numbers, it didn't have its network segmented that would have prevented the adversary from getting into the environment where there was administrative credentials. And on top of that, the passwords and the administrative credentials were stored in unprotected plain text. And so it's incredible to look at the facts of this case when it occurred in 2017. This is the 21st century. You would think this is a case from the 20th century, 1917, not 2017, but essentially at the end of the investigation, these are some of the recommendations that FTC made in order to have a reasonable security program, and that is update and patch third-party software like JavaScript, ensure there's proper configuration among any scanning that occurs in the networks. One of the others that I'm just throwing in is one that is arising from the breach I mentioned I'm handling. There was a firewall that was not patched in the Active Directory server, and so that's how the adversaries got in to drop the original malware that the Neshta malware that started exfiltrating all the data. The actual adversary got in through the Active Directory and was able to go into the domain controller. So having firewalls patched is also important. Monitoring activity, this particular client did not have an intrusion detection system. They're going to adopt one in the optimization phase. Right now, they're still rebuilding the 5 servers that were originally infected. Segmenting there also were not segmented. That is going to occur in optimization, but having, this is from the FTC, which it is true that there should be, a different segment for the unavailable or not publicly available information for your business. That could be HIPAA data, that could be financial data that should be protected under GLBA, or it could just be social security numbers of your employees. Anything that simple, those should be on a separate network. So the FTC is getting very technical in the last 2 years. It's gotten more fluent in the technical requirements to protect data. And now we are moving into a really technical regulator, the FTC, the California Attorney General, because they have decided to use some controls we're going to discuss in a second. And they've declared that these are the standards that must be met. Otherwise, the minimum standards that must be met. Otherwise, that they will rule the security to be unreasonable. So
so Elizabeth, may I
yeah,
just interject for a moment? I know
sure,
that we're about to get into the controls issue.
sure.
Question for you. Just like GDPR affected everybody that had to do business with anybody in Europe, even though you were not, maybe you didn't have headquarters in Europe. Aren't there similar situations with CCPA, which is not just about California businesses, but it's also about anybody that might be doing business with an entity in California?
That's correct. They don't use the same titles for the different roles that the GDPR does, like controller and processor, data processor, but the same obligations apply to service providers. There's not liability directly for the service providers, but the business must require that the service provider has these technical, administrative, and physical security requirements in place before they are actually giving the data to the service provider. So, in fact, you may know that Louisiana just passed a law that applies to technology technicians, requiring them to be certified, such as managed security service providers that are vendors that handle data. So that may be a new trend, Umesh, that state by state, not only will the business itself be required to have this reasonable security, but Louisiana is the first one that just passed a law requiring the outside vendor to have the technical security that they need to protect the data.
Yeah. So let's go ahead and talk about the controls, and then we'll kind of come back to something that has been percolating in my mind while you were presenting, is that most companies at this stage have been working on cybersecurity, but they haven't been working on their privacy issues. And so now, what do you see, and how do you see privacy becoming, or is there a role for a chief privacy officer coming up in companies? And does that need to be, I think it needs to be part of the plan going in, and not just when you have a breach and what do you do at that time, and it's part of the remediation. That's so I think the role of privacy is being moved to being more in the planning phase, and it's taking a stance now alongside cybersecurity. And when you put in more security, you give up privacy. When you put in more privacy, or you reduce your privacy, you become more secure, vice versa. So I guess we'll talk about the controls, and then maybe you can address that question really quickly for our viewers.
Of course. Yes, of course. So just quickly getting to the standards we believe the California Attorney General will impose during this period of enforcement now is to look at what Kamala Harris, when she was the Attorney General of California, actually announced. So in 2016, she used a definition that she found to be the front runner for her state. So as you know, we all know California has been the front runner, trying to be the pioneer for any kind of consumer privacy issues, as opposed to on the business side, where other states are more business oriented. So what she did was that she looked to an outside, she created this report. It was called the Data Breach Report. And it does a lot of things. I think it's worthwhile to look at. It's somewhat dated now, but nevertheless, it had an overview of responsibilities that businesses should undertake to protect personal information and reporting data breaches. And then it had a series of recommendations for businesses and state policymakers to follow to help safeguard personal information. So what we have heard is that that is what the California Attorney General currently is going to be referring to in its enforcement actions under the CCPA. And what that is based on, the report further defines security measures that should be taken in that report as being based on the top 20 controls and the Center for the Internet Security's critical security controls. So it's the CIS, the Center for Internet Security, published something called the critical security controls. It seems like a tongue twister, I know, but the practical effect of these controls is it defines a minimum level of information security that the California Attorney General expects organizations that collect or maintain personal information to meet. In fact, the Attorney General's office in 2016 went so far as to declare that the failure to implement all the controls that apply to an organization's environment, there is that qualification, okay? So keep in mind, if not all 20 apply to the environment, that doesn't necessarily mean it will be a lack of reasonable security, but if all 20 do, and they're not all implemented, then the Attorney General is going to find inadequate security. So here they are. This is a program that we really can't get into the weeds or the detail of these controls, but there's about 7 basic controls. There's foundational controls, and they're all hyperlinked in the actual report. You can actually go on to the Center for Internet Security and search for these security controls, and they're all still there. And then finally, the organizational CIS controls. So this is what the conversation has been about. These are a little more prescriptive, as you can tell, but the reason that they are not all mandated is because not all of them are going to apply to a particular business. So now, we are left with, okay, if you've been through the GDPR compliance process, then you've already been through some of the steps that you need to take. But the low-hanging fruit for the regulators in the very beginning of these enforcement days are going to be what is visible to the consumer and has the business taken that seriously. So they're going to be looking at websites for people doing business in California, all the clothing retail stores, all the hotels, businesses that are headquartered in California. That's the low-hanging fruit. Do they have the privacy notice? Do they have the do not sell button? Or have they said in their privacy notice, we do not sell information, therefore making the do not sell button not a requirement? And then finally, review the information security program. And I know that one of the earlier settlements of the FTC, which by the way will likely be the enforcement authority when a federal consumer data piece of legislation is enacted, they have said that you have to continuously monitor. They don't require perfect security, but they do require that after it's been made reasonable, continuously monitor that. So now bringing all of us back to Umesh's question about the elevation, I guess, of the emphasis on privacy within organizations. I think that it's going to be that person who is in charge of the compliance program related to privacy. So if it's a privacy officer or if it's a chief compliance officer, whoever has accountability for making sure the business is complying with CCPA will be invited to the table to work with information security stakeholders for what you're referring to, I believe, Umesh, is the privacy by design, making privacy the default in any new ERP system, for example, or any solution that the company is creating in-house or purchasing, just making sure application security is baked in on the front end and not bolted onto the back end. Clearly, that is a priority that is occurring in risk management teams as well as information security and legal teams.
Well, you know what, Elizabeth, we've had quite a few questions come in around GDPR. What roles does a cybersecurity lawyer play in creating? And then, what are the cyber threats currently? I think you've touched on most of those. The interesting, and I think we're going to be wrapping up here in about a minute or two. Uh, but the interesting thing is, like you mentioned, Equifax.
Mm.
And one of the things that I have found is that you take a look at these, like whether it was Target, whether it was Wyndham Hotels, whether it's Marriott chain, whether it's Facebook, um, uh, the Home Depot, their stock takes a hit because it's a reputational hit. And then investors fly in and they swoop in because they think that that stock is available at a haircut.
Mhm.
And then they think about cybersecurity weaknesses or privacy weaknesses as being rectifiable. And therefore, they go and drive the stock price back up. And so, in a way, it's funny how these companies are able to pay for the damages that they sustain, and they spread out the damages over a long period of time. And they're able to pay for it and still come out with their stock price intact, or probably end up, in most cases, higher than it was at the time of the breach. Anyway, I make that as an observation, and I'd love to get your take on it as an attorney. But a quick 30 seconds or 60 seconds on that.
That is a really clever observation. And I think that we've looked at it from the other side, because cybersecurity insurance is so important to shift risk in that direction. And if a company takes all these measures that you are very astutely point out, they usually take them post breach. But if companies did that on the front end, they would get a much lower premium on their cybersecurity insurance policy, and making that known in the public or internally among the shareholders, I think might even have the same effect of a post-breach cyber hygiene cleanup.
Yeah. And so you bring up cyber hygiene. So anyway, with that, I want to thank you so much for sharing your expertise with us today, Elizabeth. And for those of you that want to look her up, she's active on LinkedIn, Elizabeth Rogers at Michael Best in Austin. You've been a great friend of the Cyber Houston effort, and a great friend and supporter of all my other crazy efforts around town sometimes. But we really appreciate you spending your time with us today, and we'll have you back as a follow-up on this. There's so much to keep discussing.
Thank you.
For our viewers,
for your leadership, Umesh. You've been an incredible leader in this space, and one of the first, and definitely the strongest that in the state. I'm very honored to be a part of it.
Well, thank you so much, Elizabeth. That we just do, all of us do what we do. So for our viewers, we'll be posting this presentation to the Cyber Houston YouTube channel, as well as the cyberhouston.org website. And if you feel these broadcasts have been valuable to you, so please go ahead and subscribe on the Cyber Houston YouTube channel or on Facebook, and follow our pages. Cyber Houston is a coalition of volunteer businesses, cybersecurity, academic, government, and civic leaders. Our goal is to continuously educate and inform business leaders on how to manage and govern cybersecurity risk. We take lessons learned from our enterprise members, distill them down into sensible economical guidance, mostly to help small and mid-sized businesses improve their cyber posture, build resilience, become better and stronger suppliers back to the enterprise. And all of this work is done, it's volunteer work, it's free, it's about paying forward, paying into our community, and all of it's done through the lens of helping SMBs grow their business. This guidance comes in the form of the Business Vitality Guide, the guidance for the Board of Directors, the Cyber Preparedness Assessment, and the free Cyber Scan. All of these resources are free of charge and can be found under the Resources tab of the cyberhouston.org website. So thank you, everyone, for joining, and special thanks again to our sponsors, Hewlett-Packard Enterprise, Blue Lance, Reneka Digital, and the University of Houston Downtown. Thank you, Elizabeth. And with that, remember to join us on Wednesdays from 11:30 a.m. to 12:30 p.m. Central Time for our weekly cybersecurity leadership series. Be safe, stay healthy, have a great day.